Dobar dan svima, dobrodošli na drugi dan.
Good morning to all, and welcome to the second day of Privacy Week. We organized this week for the fourth time this year, and the slogan this year is Choose Privacy. During yesterday, we talked about the role of personal data in the global electoral year and the reporting of the media and protection of privacy. Thank you for following us in a large number here in the room and through our YouTube channel. And we continue with the current topics and fantastic interlocutors. And I have the pleasure to announce our first panel, Judicial Protection of the Privacy Right, moderated by our Director of the Partner Serbia, Ana Toskic-Cvetinovic. And this topic will be discussed by Nina Nicovic, the lawyer, Andrei Diligenci, expert for the data protection, personal data protection, Austria, Nebojša Đurić, Judge, Highest Court in Belgrade, Mihailo Pavlovic, lawyer. We are inviting everybody to take part in the panel, and you can ask questions in the live chat. Dear Anna, you have the floor. Thank you, Nastasia, and good morning from me, and thank you for being with us today, and many thanks to those who are with us online. And Nastasia has already announced the topic of our panel today. She announced my interlocutors. Andrei will join us online because he is in Austria. And the idea of the first panel today is to talk about the extent to which judicial mechanisms for the protection of privacy are efficient. As you know, with the adoption and the beginning of the implementation of personal data law, citizens of Serbia were given the opportunity to exercise their rights to personal data protection through several parallel mechanisms, and that was done following the model of GDPR. And now, in addition to the opportunity for citizens to address the Commissioner for Information of Public Importance and Personal Data Protection, they can also exercise their right by accessing the higher court, and they can also ask for compensation of damage due to violation of their rights. And the law also prescribes a range of misdemeanors for violations of this right. And in addition to that, unauthorized collection of personal data is a criminal offense included in our criminal code and in the media regulations. So the violation of privacy that happens in media coverage can also be the subject of judicial proceedings. And we are talking today about all these opportunities, and we will discuss whether they have improved the protection of a right to privacy for the citizens of Serbia, and to which extent the existence of parallel mechanism provides more possibilities, and whether these mechanisms are efficient. And we will also discuss the extent to which case law of the European Court of Human Rights is taken into account by our courts, and finally, whether case law of courts in the EU member states and EU court affects our case law, how much it is monitored, how well developed it is, and how it can affect case law and practices of data controllers. And we discussed the topic that may be considered to be the introduction to this panel, and we will discuss a lot our media cases. And the reason for this is based on our research and discussions with our colleagues from the judiciary. And because violations of privacy in the media sphere are frequent, a number of such cases the highest, and there are very few cases related to the personal data protection, and from discussions with judges, we don't know of any case that was concluded by a final and binding judgment. And for this reason, we will try to cover these topics by talking about practice that exists and case law that exists, and why they're not well developed in our country. We will not deal with misdemeanors. We will not talk about them because we haven't performed an analysis of these misdemeanor proceedings, and that's why we will not analyze it. When this comes to the agenda, we will discuss the practice of misdemeanor courts as well. So, Nina, I will start with you. I mentioned the panel yesterday for those who couldn't follow us. In the afternoon, we discussed the topic of price of privacy, price in terms of media practices and situation where media outlets inadvertently and sometimes deliberately violate the right to privacy uh, in order to generate profit. And we discussed only in part the extent to which proceedings for compensation of damage provide indemnification and satisfaction to victims of violations. You analyzed these cases on a sample of cases for last year, so please present us some key findings, some basic features of these proceedings, and actually whether they are meeting their purpose, whether they provide satisfaction to the victims of violations and act as deterrent for those who violate it. Thank you, Anna. This is really my pleasure to be here today with colleagues, and I also enjoyed preparing this analysis with colleagues from partners. We collected many judgments, about 80, but we focused on those who had their epilogue in the second instance proceedings. And we could see, or actually, we could see the separation of some situations in lives of our citizens. So the violation of right to privacy included publication of private photographs, encroaching their private life, publishing diagnoses of their family members or their diagnosis, and we realized that there is a healthy trend in decision making. So, in terms of violation of the right to privacy, people were trying to see whether there was consent and whether these photographs were published in open networks. The court believed that this is not automatic consent for the use of this photograph, so nobody could use that despite the fact that it was in the open network without the consent. And the court was looking at whether the identity of that person was completely discovered or whether medical records were published, and that it is a clear case of a violation of the right to privacy. And quite frequently it was related to the violation of the right of a person to honor and reputation, and citizens were trying to actually protect both rights in that way. That was the most frequent case, and the court had very clear criteria. They were stressing a huge role of the media that they have as a link with the public, and they also took into account the right of the public to know. But the court stressed that the media have this huge role in society, but they also have huge accountability and responsibility. And they were looking at whether the information was accurate, and if the journalist established that the information was accurate, whether the journalist established whether it was a complete information. Publishing incomplete information was the violation, and whether there was a due care standard that was applied, and whether where the person was affected on a personal level, and whether the information could have been conveyed in a different way, which is not violating the right of a person. And we also saw some challenges in how to define the right to privacy for several categories of persons. Everybody has that right. So we have public personalities that are in the focus of the public due to their job. We have public officials. The public has the interest to know how they perform their function, but regarding the information from their private life, there is a question whether the public has the right to know that. And we realized that the court believed that everybody has the right to privacy, that public officials have the right to protect some private information, but not the information that is related to their public office. The public has the right to know. And we had persons who are not public personalities do not perform public functions, and we realized different type of decision making in the case law. Somewhere people believed that person was in the focus of the public due to the combination of circumstances in their lives that the court believed, judicial panels believed that the public had the right to know. In other cases, the panel decided that they had the right to privacy, that it was necessary to get consent of that person for publishing photographs, despite the public interest in a particular event. And what was very good is that we saw a very clear view of the court that the public should not know the untrue information or incomplete information. The public does not have any interest in knowing information which is not accurate or which is not complete. So then the ball was pushed into the yard of the media outlets. And we realized that the context was also taken account, and that will be maybe a challenge for case law. But so far as relates to photographs, medical diagnosis, decision-making by court was quite clear. And I would also mention that court awarded monetary compensation to the plaintiffs, persons who believed that their right was violated, and the amounts ranged between 40,000 dinars for the violation of honor and reputation, and between 40,000 and 80,000 dinars for the violation of the right to privacy. This is one of the challenges in case law. I believe that it's not sufficient satisfaction to victims, that is plaintiffs, and there was also some hesitations or some differences in case law related to the publication of the enacting terms of the decisions. I believe that it should be mandatory. There should be a sanction, a penalty for not publishing that, because that will contribute to discipline on the part of the media and their compliance with the codes. And I believe that's important to secure clear guidelines, and journalists and their editorial offices should go through permanent training in this field. That's something that we could single out. Thank you. We had a workshop yesterday with journalists, and among other things, these topics were discussed. And during the panel yesterday, and I will go back to it for a number of times probably, there was an interesting question from the audience for the panelists in the context of what you said, how we assess whether a person is public personality or a person that is of interest to the public. So do you believe that you are a public figure? And whether you believe that, bearing in mind the job that you perform, whether you are a public figure, and how would you treat your privacy? It's food for thought. So a question for you to think about, and also an introductory question for Judge Juricic. What are the biggest challenges for persons trying such cases, and how it is assessed whether a certain person is a public figure? And regarding the satisfaction and compensation for damages, we heard that these are amounts that are not believed to be sufficient satisfaction for the victims that is experienced different violations, not only through media coverage, but also additional violations of human rights subsequently. Thank you for inviting me to participate in this very important event and very well organized event. From what I could gather, these are three questions. As for what colleague Nicevic mentioned, and we will touch upon that later, it is striking the right balance between two rights: the right of the journalist to freedom of information and informing the public about all the information that the public is entitled to know, and on the other hand, draw a line and strike the right balance when it comes to encroaching somebody's privacy. And it becomes even more complicated when you have somebody who is definitely a public figure or somebody who is a politician. So it's difficult to say what is the infringement of privacy or what is criticism of somebody's work. And for me, the biggest challenge is not to cross that line and not to thwart or be hindered for what journalists are doing, but just to be a corrective factor and prevent what cannot be permitted, and that should be clearly stated in judicial decisions. As for the compensation of damage, that is very important, but I believe that it is approached in a partial manner. We are talking about the right to privacy, but we have similar disputes for compensation of damages in the case of discrimination or mobbing or violation of honor and reputation among natural persons, individuals, compensation of intangible damage. So this whole concept should be reconsidered. And the famous Article 20 of the Law on Contracts and Torts, it dates back to 1978, and we have this system and concept of compensation of intangible damage, or non-material damage. And I will draw a parallel when we talk about these amounts. The colleague mentioned these amounts that were the product of practice, and she mentioned these amounts. If we take as an example some 700,000 dinars as compensation for the death of a person close to that person, next of kin or somebody, we have to take into account that we have to have different views of these compensations. That somebody suffered mobbing at work for several months and was compensated with, let's say, 200,000. And we have to see how that compares. So things are similar but not the same. These types of damage are different, and when we talk about compensation for damage, we have to take into account the entire system and see whether the laws should be amended, and the courts should recognize that it's up to the Supreme Court because they're setting the case law. And as regards this compensation, it's often presented as a fine, as a penalty there, but it's not a fine. And then the question is raised whether they act as a deterrent. Well, it's not conceived like that. Maybe we should do that. Maybe we should introduce the element of penalty and then decide on 2 times the compensation, 3 times the compensation. But it's just at this time it's compensation for damage, for immaterial damage or intangible damage. Of course, and we have to bear that in mind. And when journalists get the judgment, then they have to pay certain costs, and then this compensation that can be a lot of pressure. And when you have a claim of 1 million or 2 million, and journalists have to come to court to justify the sale, and then you have several such lawsuits, and that increases the costs of proceedings, and then people say, oh, it's a lot. So we have to look at both sides, and we should avoid a situation where these lawsuits could be pressure of them and something that prevents them from performing their job. So, as I said, the biggest challenge is to strike the right balance between all these issues. Thank you. Mihailo, before I give you the chance to comment on the recent European Court case law, you monitored that, and you have a portal where you publish summaries of the most recent judgments. I would like you to comment on these findings.
You previously conducted some other analysis where you analyzed the damages, and maybe you have some kind of a conclusion. Thank you all. let me not omit that. Thank you for the invitation and for the opportunity to talk. This paved the way to another issue. In this analysis, I was interested in seeing an overview of the situation regarding media outlet, because it was a participant in many proceedings that were held. Why? Because the European Court of Human Rights published a judgment in Gashi and others versus Serbia, came out, and the European Court determined that the civil proceedings for the protection of rights was a valid legal mechanism in Serbia, because there were many judgments where the High Court in Belgrade determined some violations and awarded damages, and therefore this was all right. And this makes sense in a part where the standard of the European Court is completely clear. We should not criminalize the society. Not everything should be within criminal proceedings. If I have to violate the journalist's right, are civil proceedings a sufficient mechanism to protect my violated right and to present the adequate mechanism of punishment against him? There is a dissenting opinion of a judge, however, which raised the issue of the justifiability of civil proceedings, and it turned out that Serbia had dozens of decisions where the damages were in the range of about 100,000 dinars. And the judge wonders, if we have a media outlet which is continuously fined by that amount and they continue to violate the rights, then to what extent is the civil procedure the appropriate procedure for that kind of violation? If they continue doing it, maybe a higher fine should be awarded to somebody or imposed to someone who is, as we would say, recidivist in criminal law. And the European Court says clearly, this is your path. Do not get into a situation that we declare your civil proceedings as proceedings that are not effective. Find a better mechanism to solve this. Judge Jurisic is right. Our Article 200 on the law on contracts and torts, Article 35 of the Constitution has probably regulated that issue better than the law on contracts and torts. But this law is in a better position because it does not limit us. This provision is wide enough in order to be able to be interpreted in the spirit of our times. And it does not make us interpret it in a way which will make us say, yes, this is a customary practice, but the current circumstances force us to put new life into this norm through practice. So no matter how much we try to annul this, the case law is the source of law. It is subsidiary source of law, but it is the source of law. It gives life to regulation. The court demonstrates what is written in the norm, and the court should give life to a norm and should interpret it in the context of life and the time in which we are. It is wide enough. Our constitutional provision gives us much more space, as I've said. And maybe on the basis of this judgment against Serbia, maybe we would be able to sit down and say, well, maybe in some situations, under the circumstances, we might think more broadly. I wanted to see what happened in that case, and we collected a number of judgments in similar cases in 5 or 6 years, and we concluded that in 7 years only this amount was covered. The amount of fines that were imposed on that media outlet were covered from the money that was awarded on public tenders by the state, and it turns out that we as citizens are paying for those fines. Last night I tried to see what the judgments were. The oldest was of 1987 versus Sweden, and it was concerning the preservation of personal data by government authorities. The violation was not determined. The judgment was in French. Unfortunately, my knowledge of French is not so good that I could analyze it in detail, but the fact is that the practice has not changed since. The right to privacy is not a right that is guaranteed by the Convention per se. It is protected by Article 8 of the Convention, and this is how all those violations are interpreted. Standards in that respect are clear. The court notes the positive and the negative obligation of the state. The positive is that the state has the obligation to protect the individual and also to ensure some kind of efficient protection of my right to privacy. And there I can immediately answer this question of whether we are public figures. To a large extent, yes. I'm talking about lawyers, of course, but this also applies on judges. We have some public functions, and our privacy is very limited in that respect. Also, the cases with which we deal can highly affect the privacy if I represent somebody in proceedings against a sugar plant, and somebody takes a photo of me buying sugar from that producer, although this is a segment of my private life, the public segment of operation makes it possible to do this, to expose this publicly. So this is logically set up, and things are working in that respect. Where I can see some omissions is the standard of the European Court, which is lacking in our case law, in our practice. The European Court has 3 tests. If we infringe somebody's right to privacy. The right to privacy is not an absolute right. It can be restricted in certain situations, but in order to be restricted, 3 conditions must be fulfilled. That there is a legal norm that says, yes, you can process these personal data. The second is that this infringement of privacy has a legitimate goal. It has a legitimate goal of protecting some other right, and somebody else can sue me because I'm violating his right to privacy for reasons. There are reasons of national security and other reasons, and they are very precisely set. And the third and the most important one is the proportionality test. So if the violation of my rights, interference in my right was in accordance with the law, and if it was aimed at achieving a goal, we have to see whether it was proportionate. And this is something that is omitted here. Actually, the second and the third condition are left out. Our decisions are based on the review which ends with whether it is in accordance with the law. For example, I cannot publish somebody's photograph by downloading it from the Facebook or Twitter account without consent. But there are some exceptions when I can do this or do not have to do this, and they are listed in the law. What is lacking are the other 2 elements, which are equally relevant, and this is where Serbia usually is criticized by the European Court. We do not weigh conflicting interests and do not see if this is proportionate. There are some 5 items that we should implement. The first is the volume of processing of data. If somebody is collecting my data for a particular purpose, that purpose might be whatever they want. How far can they go with collecting my data? Is the purpose of, that is, could they have collected, could they have achieved that purpose by collecting less information, less data? They don't have to know which car I'm driving, for example, in order to achieve that purpose. So the volume of interference with privacy. The second is the accurateness of the data. If I'm an authority that collects that data, I have to update them from time to time. I have to see if they're accurate. And some of my personal data might be published somewhere and they're no longer accurate. So you have to update them from time to time. The third is the time period for the preservation of data. You can preserve them indefinitely, but there must be a limitation if there is no longer the purpose of collection of the information. And then there is the purpose, limiting oneself to the purpose of collection of data, not going outside it. And the fourth is the procedure of transparency of collection of data. It's not a problem for the public authority to collect my data for some purpose. I have to be in a position to know at all times why the data was collected, for which purpose they're being used. At some point, they have to be made accessible to me. If they are destroyed, I have to know that they have been destroyed. So the moment that you violate my privacy is limited. You are processing my data, and I have to be able to see what you're doing at any given time. And the final issue is the issue which we will probably review in the future, and this is topical before the European Court, and these are the modern problems that actually are an ailment of our Interior Ministry. Artificial intelligence, there are programs that collect all the information about me and make a profile of my personality, or search engines. Somebody can see what I have searched and make a profile in that way. And of course, the course of data, how you store the data, where you send the data, where they end up. These are the things that the European Court is dealing with. There's also mass surveillance and other things. But these are the key issues that the court is dealing with now. Thank you. And you have given me an introduction for the topics that I would like us to discuss with Andrei. Mihailo, you have presented something that's covered by the GDPR and our law, the obligations of the data controller and the data processor, and the rights of the persons to whom the data refers. And we're trying to say something about the case law in the European Union. And the question for Andrei is to what extent in the European Union, especially in Austria where you live, implement their rights according to the GDPR, and primarily referring to the requests for the realization of rights before the court. So to what extent has this been put in practice? A great hello to everybody, and first of all I would like to thank everybody for inviting me and giving my contribution in this way, and I hope that next time I will be able to attend the panel in person. And as for your question, it is very interesting because we should bear in mind the proclaimed rights. According to our law on personal data protection and the GDPR, it is possible to have the damages for material and immaterial damage. Before this panel, I found 32 court decisions, and it turns out that immaterial damage, unlike Serbia, for which I heard that the amount was about 100,000 dinars, primarily in media disputes, According to the GDPR, the fine for immaterial damage was between 50 euros and 10,000 euros by different courts. But I will say something more about this later, and about the situations that led to these immaterial damages. But we should say, first of all, that in order to establish accountability according to GDPR, the violation of the GDPR does not make it possible to get damages without the loss or damage happening itself. So if something is regulated by the GDPR, this is not a sufficient condition for establishing the damage according to the GDPR. And also the importance threshold is another thing. This is something that was discussed already by the colleagues, and the Article 200 of the Law on Contracts and Torts in Austria and in Germany, there must be this importance threshold in order to award immaterial damages. There must be circumstances of violations of the personal rights, and the bigger the violation, the more likely it will be that this immaterial damage will occur. What are the reasons for immaterial damages in the cases that I have covered? This turned out in multiple situations as a standard rule in which judges award immaterial damages. This is the loss of control over the data, over personal data. For example, this could be data breach, then the transfer of data to another controller. Another element that turned out to be important in the case law is the affinity towards a political party when this is done without the consent or informing the individual about this. This case is very interesting because it concerns a large number of people. About 6 million people were affected in this scoring, this assessment of political affinity. What are the other reasons for awarding immaterial damages? In multiple situations, it was confirmed that illegal processing, especially of protected data, such as healthcare data and other sensitive data, was one of the important elements where immaterial damages were awarded. There was also an interesting case regarding the transfer of data to other data controllers, where the data controller came into the position to find out the profile of the person who was competing for a job. And because of the stress of whether the contract will be extended, the court decided to award immaterial damages. Also, the publication of photographs on social media or newspapers without the consent or after the withdrawal of consent was an important element for awarding immaterial damages. Also, the deletion of photographs from web pages was another important element. Also, the publication of data on an employee after the termination of employment was another reason for awarding immaterial damages. Recording an employee for advertising purposes without their consent is another element and the possibility for awarding immaterial damages. Another thing that's interesting in the labor law environment, in a case the court awarded immaterial damages and demonstrated this important threshold in a case of GPS monitoring or surveillance of an employee. also tardiness of response concerning the access to information according to Article 15 of GDPR. It represented an important element for awarding material damages. So the mere tardiness, also incomplete response, was another element for the awarding of material damages.
Also, it's been confirmed several times that unlawful registration in the credit bureau is one of the bases for the compensation of intangible damages. And what is interesting in this body of documents that I encountered is that intangible damage is justified in the situations where the person loses the opportunity or ability to determine who will have access to their personal data. That came out of case law. In this body of text that was the subject of my analysis, it was interesting to see that these situations are used in labor law cases, and they are also used as some supplement for the work of regulatory bodies. In Serbia, it would be on top of the decision of the commissioner, so that's used as an additional element, this compensation of immaterial or intangible damage. And what is important to stress in relation to this first part of our discussion is that these submissions to the or applications to the commissioners are not paid. There is no fee on them, and that's the case in our country and in the EU. So individuals use these opportunities to go before court, and that's how they also exercise their right to intangible damage. So they have a blank confirmation in such a way that their rights are violated. And that's important. And just to draw a parallel with what Nina was mentioning, when she talked about her analysis, we can establish this parallel related to the publication of photographs or medical information without consent of individuals. These are all risk factors that constitute impact on individuals. In our paragraph 75 of the preamble of GDPR, it lists all the risks for individuals. And we can identify this parallel with what was going on in Serbia. That's all by way of introduction. I would have a lot more to say, but that would be enough for this introductory part. Thank you, Andre. And I would stay with you for a while, if you don't mind. There are parallel mechanisms also under the GDPR, and I would like to know whether it is you have the impression that the existence of these different possibilities. You mentioned the differences related to the costs of proceedings and expenses. Very often, these costs are the basis for compensation of damage. And do you have the impression that it is improving the level of protection? And do you know about any situation where in parallel proceedings different bodies issued opposing decisions, and how this issue was dealt with? Well, that's a very interesting question. In principle, in Austria, there is a rule that two proceedings cannot be conducted simultaneously. I'm talking about Austria. I don't know about other systems. Maybe that's possible in other countries. But I cannot have litigation or civil proceedings and also file a complaint at the same time with the commissioner, although the title of that office is different here in Austria, but that's the counterpart. So one has to wait for the decision of a body that initiated a procedure or proceedings, but there are several mechanisms. It's important to stress something that is very important for each and every one of us. I can say, based on my personal experience, that the right of access to information under the law on personal data protection and also under GDPR Article 15 is a very important element in the exercise of rights of individuals. Because when you file that request, so data controller has the obligation to respond to that. And that's very important. It's one of the first mechanisms that people can use to protect themselves. A commissioner is there as a mechanism of complaint, and there is also administrative dispute. But administrative dispute, for those who are more familiar with administrative law, it's related only to the legality of the decision issued. But I have a situation from Montenegro, and bearing that situation in mind, where the Personal Data Protection Agency issued a decision talking about pseudonymization, which is still not included in the applicable regulations in Montenegro. So they violated this part of the law, which is actually the former Serbian law of 2009, the personal law on personal data protection. So there is no effect of the administrative dispute. And so there is another possibility in the GDPR and in the law on personal data protection, so that is compensation of material or immaterial, or a possibility of a class action. So this is where a situation where several individuals join in a lawsuit or a claim in order to exercise certain rights under the law on personal data protection. As far as I know, that's not possible under the decision of the Constitutional Court. So this provision is not implementable in Serbia. And this is the situation where the commissioner decides on something, or administrative court. But this is there is a possibility to get compensation for material and immaterial damage or intangible damage, and we can talk about the situation in Montenegro if there is time and if there is interest. We can discuss that later. Thank you. I think we will have time for another round of questions. And maybe Judge Đuričić can make some comments on the situation in Serbia in relation to what Andre was mentioning. We mentioned that there are few cases related to the personal data protection, or actually under the law on the personal data protection, or there are no such cases. So what could be the reason for that in your view? And Andre mentioned class action. Could they be the path to take, particularly for those cases where we have violation of the security of data, where the large number of citizens had their right violated, and data breaches related to a number of citizens. And Nemanja can also comment on that. As for proceedings under the law on personal data protection, the analysis and my experience show that there are few such cases, or there are no such cases. I didn't have a chance to work on such cases. And we were talking about recording cases in the judicial databases, and that it constitutes a difficulty for certain analysis, but it's obvious that there are no such cases. Well, the court works with cases that come before the court, So it's related to general level of information or level of information among lawyers, or maybe work of the NGOs. We heard Andrei, and this interesting practice related about cases related to intangible damages or late responses and compensation due to that reason. And I believe that increasing the level of general information would contribute to launching such cases. As for class actions, we discussed that question in the past as an interesting question, not only because of this type of cases, but because of all these repetitive cases that are flooding our courts. And we were discussing whether class action should be a solution. I think that it is necessary for us to have some mechanism to deal with such situations, whether we will opt for a class action or some pilot judgments, that some cases should be dealt with on a fast-track basis and to reach the Supreme Court as soon as possible, and maybe through some Supreme Authority we can deal with such cases. Class action is an interesting solution, but it should be reviewed from different aspects. Maybe it could be a good solution for such cases. Several things. The first is related to this great mechanism that gives me the possibility to conduct proceedings, one proceeding, and all other time limits are suspended. And since we don't have it, and we don't have this mechanism, we have to use all the weapons that we have at our disposal, all the arms, and see where we can make progress. And Serbia had a number of judgments where applications before the European Court were dismissed because of the lack of exhaustion of legal remedies. So this multiplication of mechanisms can be detrimental to individuals. If I have the possibility to institute civil proceedings, criminal proceedings, procedure before the Commissioner for Equality, Commissioner for the Protection of Personal Data. And if you need a lawyer for all that, I can just imagine in principle what the price of that would be, how much you have to pay for that, and how many things you have to initiate at the same time. So this multiplication of mechanisms that is quite widespread in our country, because we have a large number of cases that are starting to prescribe procedural provisions and procedural norms, for example, the law on prohibition of discrimination. So we are putting people who perform this job to look at all kinds of laws instead of looking at the procedural law, because each substantive law is trying to include procedural provisions in it. In principle, I'm not against that, but I think it's getting too far because all these laws are now getting a set of procedural provisions, and that is changing the situation. This is quite convenient what Andrei talked, but we are not in such position. We had class action. It was declared to be unconstitutional in its full capacity. So right now we have the possibility for 500 of us to institute litigation. We are co-litigants then, all 500 of us, and then the judgment can be taken for, let's say, 30 of us, and then others can continue. But it's not class action per se. Class action is dealing with a problem that appeared in court in a systemic manner. That's how it should operate. But what we are doing here, instead of having 500 proceedings, or 500 of us have one proceeding, but this is not the same. But we can discuss it. I would like to follow up on what Judge Đuričić and colleague Mihailo said. When we see unauthorized collection of personal data in criminal proceedings, we see that there is a low level of information on part of the individuals about their rights. We could see in practice that we have several situations when citizens do not have their attorneys, when it comes to private criminal suit, this is dismissed, because these are not offenses committed by officials. So we see that citizens do not understand what they need to add or submit additionally, and even when they have their attorneys, the court was asking the lawyer to understand the subjective elements of the criminal offense, and they still do not understand it properly, although these are attorneys, lawyers who should understand it. And we see that both criminal and civil proceedings take too long. We see that the case is often stalled or stuck in pre-trial investigation, and we have this lack of communication when it comes to unauthorized collection of personal data by an official. We have a lack of understanding between the prosecutor's office and the institution and the police. And it seems that they do not have proper communication or communication which is good enough. Maybe the request for the collection of the necessary information is too broad, which is sent from the prosecutor to the police, then the police officer will need too much time to collect that. If the instruction from the prosecutor is not precise enough in terms of what needs to be collected to prepare a bill of indictment or indictment. So we see that there is a lot of back and forth between prosecutor's office and police, and citizens are actually denied of their right or deprived of their right because of the statute of limitation. If you, for example, for some offenses in this field, the sentence is a year or two, and when you have pre-trial investigation that takes a year, then it leads to the statute of limitations being activated. And as for unauthorized access to databases, it also falls under the statute of limitations in some 3 years. So we heard from Andre, and Mihailo was talking about that. It would be good for the statute of limitations to be suspended while other mechanisms are being used. Maybe these mechanisms are more adequate. We should work on better understanding on the part of courts, prosecutors' offices, police officers, because we actually realize by performing this analysis that there is this thinking on the part of the law enforcement agencies that these are cases that are not that urgent. So, for example, we have some other offenses like stalking or sexual harassment. People do not think from the standpoint of the victim, and you have slow activities without any ill intention, but it's simply as such. And we can see that this criminal legal protection of citizens is not up and running, if we put it that way, and we should work on raising the awareness about that, right, on some very specific guidelines, clear guidelines, and that will definitely result in media abiding by that, both in criminal and civil proceedings, because if courts and prosecutor's office do not have clear guidelines, the media outlets will not know how far they can go. So we should talk about that more and work on very specific things and simply improve this, be it by case law or legal framework, that these are cases are treated as urgent and some mechanism is provided for that.
I'll follow up on what the colleague said. Media use something that it's a nature to look over the fence, to peep over the fence, to see what the neighbor is doing, to see what car they're driving, what the wife has bought. So this is the infringement of privacy on a daily level. And when we raise this to the level of some showbiz people like to read about this. This attracts their attention, and this is what media take advantage of. There should be some right measure and some limitations to this. But when we're talking about court protection, we're talking about civil proceedings, the adequate violation should have an adequate mechanism. If we're talking about this violation that I'm talking about, this is some good upbringing at home. If somebody is violating some of your rights, you should not address the media. It seems to me that when somebody is writing the law in order to protect a right such as this one, nobody is analyzing sufficiently to what extent the court proceedings can be urgent and effective. If an average court judge has between 350 and 400 cases. According to regulations, 1/3 of those cases is urgent, and they cannot all be urgent. And of course, the court is trying to distinguish whether this is a violation because this is somebody's photograph where a similar photograph had already been published and now a similar one has been published too. We must never lose from sight the fact that court proceedings are slow and it's difficult for you to do something within 10 or 15 days, or even to issue some kind of a special measure within that deadline. So when we talked about parallel mechanism, if we take as an example media cases, and if we look at the actions of the press council, it's interesting to see to what extent the violations recognized by the press councils have led to the cessation in future of similar violations. I'm sure that there are some conscientious and good journalists, because if the press council points at something that is bad practice, they should realize and avoid future violations and avoid the court joining the resolution of that problem. Yesterday we talked about to what extent the media should educate the public and get it accustomed to greater standards in reporting. And Minja, you said that there is insufficient awareness in the judiciary and among the citizens that unlawful collection of data is a crime. And there was a case against a journalist, and somebody asked about some kind of property, and the judge said, well, unlawful collection of property data is a crime. I would now focus on questions from the audience. Yes, please introduce yourself. Tatiana Stupar. I work in legal consulting. I have a few things to say which are important for our proceedings. Deadlines, statutory deadlines that should be imposed for procedural activities in any of the proceedings. then the prohibition to change the number of cases. There are huge manipulations regarding the numbers of cases, and it's impossible to monitor what is going on with the case because the number of the cases changed. The change of the judge or the prosecutor means that they can be changed only or replaced only in exceptional cases, protection of judges and prosecutors. In terms of procedural identity that is accessible to all, this leads to great uncertainty of judges and prosecutors in cases. And the change of case law regarding the imposition of those material and immaterial damages. Other questions? Good morning. I'm Lazar Petrovic. I'm a student at Master's Studies at the Law School in Belgrade. I would like to thank the speakers for really exhaustive presentations and the organizers for organizing this entire event. I have 3 questions or comments, and they all refer to what Mr. Mikhailov was talking about, but I would also like to hear other speakers as well. Regarding the dissenting opinion in the judgment against Serbia, as far as understood from what she said that it was a question whether the civil proceedings were an efficient mechanism for the protection of privacy in the context which was discussed in the judgment. I don't see what other mechanism, if we exclude the criminal proceedings, which I do not regard as correct, could be an efficient parallel for the civil proceedings. And I would like to know whether you might think that it would be better to talk about the appropriate punishment, because I don't see what could actually substitute civil proceedings. The second thing that I would like to know regarding those 3 criteria that you mentioned, legitimate goal, regulated by law, and proportionality, in a large number of European Court of Human Rights judgments, I've found the 4th criterion regarding the necessity of interference of the state in what is necessary in the democratic society. So does this proportionality refer to this as well? And there are numerous judgments of the European Court of Human Rights, and one is striking. The then Princess of Monaco was the one who filed the application, and the court was trying to decide what is the level of protection awarded to public figures within the private sphere. When a public figure has an appearance in the media or something else, the question is what of the things that they're saying that is out of how they're behaving in the public is in the interest of the public or not. In other words, whether when some public figure goes into a shop to buy a shirt, whether this is in the interest of the public, whether this activity is protected within the context of protection of the public. So I would like to hear your opinion about this. Maybe another question, and we might go to answers, because we already have 6. Lawyer Astribac, thank you all for your speeches and presentations. I have a short and more specific question. If some private data of citizens became accessible to the public owing to a hacking attack, and if they became available to the public, if the right to privacy was violated, in that case, would the civil liability lie with the data controller, or would this be a crime committed by hacker only, or would it be assessed as joint responsibility? So shall we start with the answers? As a moderator, I will have the right to choose. Maybe Andrei can comment on the last question if he heard us. Andrei? Yes, I heard you. This is a very interesting question. It's an issue of data breach. I wanted to mention this, but the colleague gave me the cue, so to say. And this is the data breach case that happened in Serbia, not just once, but in several occasions. The question is whether the data controller could or should be held liable according to the applicable law in Serbia, according to the law on the protection of personal data. Certainly, because it envisages the liability of a company or an institution. We had a situation during the peak of the coronavirus that data such as password and username were available on Google for a period of time. And hackers, for example, blocked the operation of the entire administration of Novi Sad for nearly 2 months. And according to the claims of the then mayor, I don't know if he's still the same, personal data were not affected. I don't know how you can expect this how you can explain this if your system for the issuance of building permits, for the calculation of salaries of civil servants in the city authorities is not working. How cannot those data be encompassed? And we had the latest case of apps. So according to the personal law on personal data protection and the GDPR, the liability is on the data controller, the city of Novi Sad, and in the case of COVID, the Ministry of Healthcare. And there's no third-party responsibility according to these regulations. If a third party entered the system, this is a completely separate criminal liability, separate from the responsibility of the data controller, according to the law on personal data protection. In Serbia, you have a situation where there are different categories, from entrepreneurs to some administrative officials, and this is different when compared to the European Union. But we should also bear in mind that those situations are very important, that it's important to take them into account, because Austria had a big problem with whether the individual is to be published or an entire organization, because this was not regulated by the substantive law that an organization could be published and individuals be published. I don't know what the situation in Serbia is, whether somebody can, according to the substantive law, directly punish an individual as the head of the organization, or if it is permitted to punish the company. And Austria is not imposing those fines, those administrative fines, for that reason. And the violation pertains to the loss of control. In addition to the administrative punishment, there's also the possibility of the payment of immaterial damages and material damages, as I've said, because individuals lose control of their data and public authorities no longer know where the data will end up. And it's possible to use the individual's data financially, because the data can be sold in the European Union and elsewhere. That's why hackers hack the systems, and that's because the data, in addition to having a material value, also have a financial value. We will see whether this will activate it in Serbia because of the examples that you have mentioned, and the latest one with EPS. Maybe Judge Juricic could comment on the first question. It's not in connection with the topic of the panel, but please comment. Briefly, currently, the selection of judges has been completed. The some 10 judges should go to the appellate court, and another 15 judges, there are vacancies for 15 judges, which means, we also have judges which are to retire, and 571 will retire in the near future. Judges are leaving most frequently because they go to some other instance or to some other court. And as for the change of number of cases, I can understand to what extent it can be a problem to you in practice. This new judicial portal should make it possible to search the case according to the new and the old number. And I understand you as a citizen that you have this problem. Secrecy of judges, partly I agree and partly I do not. Some cases are open to some proceedings are open to the public and others are not. We should prevent the secrecy of the name of the judge. Sometimes media exaggerate and they say Judge Juricic postponed the trial or did something else. The judge does not adjudicate the case on his own personal behalf. Judges should endure the publication of the name up to an extent, but there can also be abuse. I think I've answered all the questions as briefly as possible. Mihailo, defending what Judge Juricic has said, let me just add, yes, we have a huge fluctuation of people at courts, and this is the basic problem of the entire system. This fluctuation is enormous. Judges go from one court to another. There is this mechanism for a case to keep the initial number. Bosnia has this mechanism. They keep the same number, they just add certain letters at the end. But this can be actually taken care of through this new database. The primary problem is the huge fluctuation on the labor market at courts, and this is the situation. This ends up in the extended proceedings, etc., etc. And as for the names of the judges, try to find out the name of the judge if you have a constitutional appeal. It's impossible, and this piece of data is extremely protected. And if I may try to answer the latest question, the last question that was asked. When you collect data, how they end up where they ended up. If they ended up where they did through my subjective responsibility as the data controller, then we introduce the subjective responsibility of guilt. If we add to that the objective responsibility of the institution that collected the data, then we have the subjective responsibility in that moment. So depending on the circumstances, we investigate how the data leaked out of the institution, and depending on that, we will know who will be responsible. That's what I would like to add to the obligations that are regulated under the law on personal data protection, which regulates the adequate protection measure. And in that context, whether this was objective or subjective, and if we determine subjective responsibility, then the institution might not be guilty. If I'm somebody who sold the data and took some money, it could leave the space for the institution to be excluded from responsibility because I recklessly acted in that case. I have my personal opinion, but I'm the moderator. I cannot offer one. This was just my idea how this could function. 3 questions. Well, it's my age, probably. I haven't remembered them all. As for the first question, the third test, the test of proportionality, pressing social need. This is it. This is the third test, but only in the context of the given circumstances we observe this. This test is actually the weighing of conflicting interests. We have the protection of personal data and the freedom of expression. The third test serves the purpose for me to weigh the conflicting interests and see how proportionate this was. Was there a pressing need for me to interfere in somebody's rights and publish his data? And was it necessary to process those data? The third question was Princess of Monaco. I also remember that. It depends. In principle, this should not be, if I have to give a general answer, this should not be a topic of interest for the public at the given time.
I can imagine a situation where it could be of interest. I mentioned this case that I'm working on a case against a sugar factory, and it was very high profile, and then somebody catches me buying that same sugar. So depending whether Princess was saying this or that about that fashion designer, and then she was caught by, then we can have the situation where we would discuss the public interest, maybe, and what should prevail. This field of personal data protection is very narrow. If somebody is intending to undermine my right to privacy, this right is limited initially. So the burden of proof is on the government. The burden of proof is on the person who decided to infringe my right or interfere with my right. Dissenting opinion. The idea of this dissenting opinion was the following. You will either increase the amount of fines or sanctions that you award in media cases, or this mechanism is not operational, effective, and we will ask the criminal court to step in. So they're saying at this point, we think that litigations are producing results, and this dissenting opinion says that that's right, and you have fines, 100 or 120,000 dinars, but you have the same media outlet that has been doing that in continuum. So if you don't increase the amount of sanctions, then the question can be raised of the effectiveness of that mechanism, or maybe criminal law protection should be activated because these sanctions are not yielding results. So that means that we maybe have to increase the level of liability and maybe go for a criminal liability. Nina had a comment, and then we can continue. I would like to follow up on this question about who could be responsible. I agree with what Mihailo said about hacking attacks, and I think that the unauthorized collection of personal data, that's where a hacker could be held to account, because they collected somebody's data without authorization. But through the investigation, we could establish whether there was some omission on the part of the official in order to be able to bring on board paragraph 3 of that article. But what is important, bearing in mind the complexity of that criminal offense, when it comes to hacking attacks, we would very quickly reach the point where it would be statute barred, and then we have the question of criminal legal protection. There are also other criminal offenses, unauthorized access to the computer or network. Yes, but that depends on what can be proven in the investigation, and that depends also what the strategy of the prosecutor's office would be. And that also depends on the amount of evidence they can collect. So you have to have justified suspicion in order to have the indictment, so it requires a larger amount of evidence, and we need to see whether there was really some kind of intrusion into the protected system, because sometimes you don't have that time that is necessary to find these digital footprints or traces of the criminal offense. And that's why the prosecutors have to act quickly, and sometimes that's why they opt for simpler criminal offenses, which entail lower prison sentences. I mentioned this. I mentioned that we have a lack of understanding on the part of the police and prosecutors in when it comes to the collection of data, and for example, in simpler cases, and you can imagine how complex it is when it comes to hacking attacks. So, as for criminal legal protection, in my experience, police and the prosecutor's office do not have enough tools to be able to cope with these criminal offenses in a timely fashion and in a more effective ways. Maybe certain things will be clear after the workshop that we'll have after this panel. This guillotine of statute of limitation is working perfectly, bearing in mind the understaffing in the judicial system and all other problems. Any other short questions? No? I would like to just give you the opportunity to make final comments based on what we've said here. Can we conclude that judicial mechanisms are efficient, or they're not? And what should be the next step, bearing in mind that they're not? In terms of the legal framework, they're there. But from the standpoint of a person whose right was violated, the victim or injured party, I think it's not quick enough. I think that they cannot get satisfaction in that manner, and that's why we need to definitely improve something, because we see also in civil proceedings and in criminal proceedings there is a slow pace of decision-making in some criminal offenses, particularly those committed through the internet. We have the problem with the collection of evidence, we have the lack of understanding on the part of individuals and attorneys to offer proper quality of evidence so that court can issue a conviction. And in litigation, we have some good decisions that can be in line with European standards, but courts are overburdened because of the factors that we mentioned, understaffing, huge number of cases, and so on. So I think that we have a good legal framework, but we do not have sufficient speed in acting and trying, and that's why citizens cannot exercise their right and protect their right to privacy. I would point to one segment that can contribute, that's specialization of judges, not just first instance judicial panels, but even more importantly, panels of judges in the second instance, because we have large fluctuation of judges. And when you come to the higher court, you never acted with this in those cases, and you have to get familiar with that. And you have all kinds of cases, copyright, intellectual property, family law, and you have to be a specialist in many fields. And if you're a specialist in many fields, then you're not really a specialist. And I think that the answer is specialization in different bodies, so that when you get something, that you know what to do with it. You have to study the case, search the case law, and you have also decisions that you have to make. It's quite challenging, and you're expected to prepare a high-quality decision. And I think that the assessment of the decisions, according to the analysis of the colleague, is positive, and I think this is the result of the efforts and work of my colleagues. I just want to add that. I can add that courts are conservative in principle. Things change gradually, and in principle, that's good. If we are introducing something new, we need to do that carefully. It's not something that is criticism. But when we have types of cases that have been resolved by some other courts, like European courts, there is no need to dwell on these cases and spend time trying to find something extremely new. And many things have been considered by these courts, and the question that we will face very soon is collecting biometric data, encrypted messages that are not forbidden, but what are the purposes that they used to. These things that are already part of our lives, and we're working on them already. These things have not reached courts, and we're still struggling with the fact of intrusion of privacy, the extent of it. So how will we deal with biometric data collection or face recognition? Maybe I'm going too far, but these are the topics that are now before the European Court, and serious debates are being conducted, and I would like such debates to be conducted here. Well, it will reach the agenda quite soon. Proceedings have already been initiated for deepfake, so it will be interesting to see how the court will act. Andrei, just in conclusion, from your other angle, what's your impression about the judicial protection of this right?
Thank you for giving me the honor to be the last speaker. Just briefly, according to the law on personal data protection, the judiciary has not been encompassed. Data controllers are not courts. This is the answer to the question from the audience, and now I will conclude. As for the possibility to get damages, I think that the problem is not with the punishments, with the amounts that are envisaged in the law on personal data protection and other mechanisms. I rather think that it's important to implement those regulations. As Judge Mihailo said, that we have an institution that worked much better, did not do its part of the job. And when it comes to the fines, they go up to 17,000 euros. When it comes to administrative fines, I'm not talking about the payment of material and immaterial damages. They go in parallel. So if somebody was punished, we would have had much more effective implementation of the law on personal data protection and other regulations. I think that the citizens are not aware enough of their rights, and the bigger problem might lie in the implementation and the education, as Judge Mihailo said. There's insufficient knowledge on what should be protected and how, because unfortunately only individuals understand this once they themselves encounter problems with that. Thank you. Thank you, Andrei, and thank everybody for your questions and for your participation. I think that we can make the standard conclusion that there are many things that we have to analyze in this respect, but there's definitely a lot of room for improvement and improvement of practice. Thank you very much. And Nadia, I would like to thank dear panelists and thank you. Now we will have a short break until 1, and then we will talk about the EPS case and cybercrime.
Dobrodošli nazad za one koji su se
Welcome back for those of you who have just joined us. So welcome to the second Privacy Week. As I announced before the break, we will now hear the presentation of the case of Elektroprivreda Srbije. Our panelist, Dr. Milana Pisaric, Assistant Professor of the Faculty of Law, University of Novi Sad, and Ivan Marković, Expert in Information Security and Hacker, will tell us what this is all about. I can't wait to hear what they have prepared for us. So Milana, the floor is yours. Thank you. Good afternoon, everybody. It is my great honor and pleasure to be here, and I would like to thank the partners for inviting me, and I'm happy to see the well-known and smiling faces in the audience who are ready for us to share some experiences and some knowledge and to discuss something. And the topic that we're going to deal with is cyber attack on critical information infrastructure. Unfortunately, the case of electric power industry of Serbia. So we have half an hour for the presentation, and I will try to stick to the presentation which I prepared primarily for myself, to limit myself to the topic, and to leave some time for the second panelist, who is not physically here but who will join us. Even you will join your part. Let me just explain the structure of the presentation today. After the introduction, we will briefly say something about the facts that are known to the public regarding the attack at the EPS. Then the third part will be dedicated to the findings of the Safe Balkan Forum, the expert public, and the fourth part is dedicated to the analysis and presentation of the law on information security. As for the introductory part, cyber attacks at the critical infrastructure have become more and more numerous in the past few years, and targets, the forms, and the number will quantify, become more and more complex. So it's no wonder that the need for legal regulations in terms of preventive action and the action after the cyber attack has appeared as a necessity both in the EU and in Serbia. As for the EU, in 2008, they adopted the directive on the identification of the critical infrastructure and the need to protect it. And we also have the directive of 2022. As for Serbia, we have the law on information security, which has been harmonized completely with the NIS directive, and there are also legislative activities aimed at improving the existing solution and harmonizing it with the relevant directive. And currently, we are working on the criminal determination of the attack. The literature recognizes those attacks as cybercrime. If we look at what is going on at the level of the United Nations and the negotiations and the convention that is being prepared, we can see that they also recognize the need for regulation. As for the regulation in Serbia, among the crimes against the safety of computer data, we cannot find the adequate legal qualification that would completely cover the specific features of the cyber attacks on critical infrastructure, because crimes such as unauthorized access to computer data or even computer sabotage are not sufficiently specific to be able to protect the critical infrastructure. And what is the critical infrastructure? There is no global definition. Critical ITC systems are regulated at the national level, and this is how we come to the attack on the electric power of Serbia. We have prepared a brief timeline on the basis of data that are available to the public. We can see that on the 18th of December until the 22nd, that's the last date that we put here, the following happened. On the 18th, the incident was reported to SET. On the 19th, we have the EPS statement. On the 20th, we have the report of EPS to the Commissioner. On the 24th, we have the notification of the killing ransomware group. On the 4th, we have set in the media. On the 7th, EPS was removed from the killing group page. On the 12th and the 18th, we have the killing ransomware group statements. We will see what they're dealing with, and we have the statement of EPS on the 22nd. On the 19th of December, the EPS persuaded the public and tried to reassure the public that nothing of the personal data and functioning of the electric power system has been brought into question, and asked them for patience. On the 20th of December, according to the data that Radio Free Europe actually that we found out from Radio Free Europe, it is said in the report to the Commissioner that the contamination and the violation of data has not been determined so far, and the databases in which citizens' data are contained have been isolated. So EPS has tried to reassure the public that their data have not been violated. On the 24th, we have the first killing statement, an announcement that the data will be released in 10 days. What is interesting is that we can see from the statement that the group accuses EPS that they did not take care of their internet security and the safety of its customers and partners, that they did not get in touch with them, and that they did not want to resolve the issue without risks to the personal data and risk to the reputation. And they explained that they haven't received the ransom that they requested from EPS, that no negotiations have started, and then they threaten. We have stolen a large number of data, and it will be released on our blog within the next 10 days. On the 4th of January, we have said the source is Danas, and there is no information that hacker groups jeopardize the business operation of EPS. Hacking groups trade with different information, but there's an open issue whether and to what extent the data is valid, or maybe there's some obsolete or fabricated information. It is said in the response of the National Center for the Prevention of Security Risks in ICT Systems, or SET, asked by Danas regarding the killing attack. On the 20th of January, Killing Group mentions the 15th of January as the date when the data will be released. This data has passed, and on the 18th, Killing says that they will be released on the 22nd. On the 22nd, we have a statement that the portal insight into the account is available. Thank you for your patience. We apologize. And these are briefly the facts that we know. As for the data that are free to download, nobody has downloaded them so far in view of the method of operation of the platform, because these are 34 gigabytes of data, and we will now start with questions, and Ivan will respond their questions as an expert. He will now join the discussion. Ivan, can you hear me? Yes? Okay. So, shall I ask you the question that we've agreed on? Can you tell us, please, something more about your analysis of EPS before this incident? Some 10 days. Just a second, I have some kind of an echo. You can hear me well? Yes. Okay, I will disregard this. I think that it was on the 6th of December on our forum. We published an analysis using, I'm sorry, this is distracting. I have an echo. It's very difficult to talk. Can somebody help me with this? And I will continue. So we did an analysis, and using publicly accessible tools that you can see on the screen, SOC Radar, where anybody can add any domain on the internet and the internet address and get the data regarding what this tool can find on the dark web. And what we found, and you can see this, is that about 135 credentials of employees were on dark web, and also 35 Stealer logs, 75, sorry, Stealer logs. What does this mean? It means that somebody has a program, a virus, on a computer that is used by somebody from EPS. It can be somebody who can access in an unauthorized way, access the services from the outside. And what we detected through those logs is that there are some local addresses, and on the right-hand side you can see that we found a lot of those internal addresses that end with apps.local. And let me clarify, these are the addresses that cannot be accessed by anybody from the internet, only by somebody who is physically or virtually connected to the apps network. This means that internal systems have been compromised. And these data date back to March or even August for some local address. And there's also Peace Apps, which is in red, which is Legal Information System, and SAP, this is for the management of users, and many more things on the system. In order to be sure that this data is correct, we asked their colleagues from SOS Intelligence, from the a company from London, SOS Intelligence, who also searched the dark web to check this information. In a few days, they sent us similar data that they found. So this was 12 days before EPS notified the commissioner about the incident. And data date back from March. And we have everything on the forum. Can we switch to the next slide? I don't know if there are any questions. Can you tell us something more about your previous OSINT analysis of apps.rs? Yes, in January, we observed that not only on dark web, but also on deep web, which can be accessed by anybody using Google, that there are accounts of apps which include personal data of citizens. And we covered the electric power distribution, EMS, and Yuzhna Bachka electric power industry, and we found multiple evidence that their computers are used for hacking attacks on other resources on the internet, and then their data are sold and used probably for other scams. You can see the screenshots published by BIRN. I think that this is EPS and the electric power distribution company on the right-hand side. And through the dark web analysis and OSINT analysis, we reported the cases to the commissioner, to the national center, and to the state center. In the case of dark web analysis, national center and CERT did not say anything, and the commissioner sent the response that he did not have the competence for this. He didn't have the jurisdiction. He conducted the supervision regarding the other case, and he said that nothing was compromised. EBS said that nothing was compromised, and EMS confirmed that the accounts were compromised. So we can see two cases that in which the data had been compromised even before the attack, and that this incident that was recorded now actually had been present for a long time. So we have previous incidents, and this is the culmination. This is the climax. Yes, Eb. How and when did you find out that EBS was the target of this specific attack on the forum? Well, we did not know this much before. You can see that on the 18th we learned that there were some problems, and we found out that this was an incident only when EBS published this on the 19th. Before the information that this was the killing group, what were your assumptions? What could this have been? Well, whenever there's such an incident, we are trying to use publicly available services to see whether some major attacks were going on in our country. And we noticed this Kaspersky statistics, that there was a greater attack, botnet attacks with crypto aspect on those days, and we assumed that this was probably ransomware, but we could not see on the basis of the documentation whether EBS was really using Kaspersky or not, but this was one of the leads that we used in this case. And the next thing that we saw, we started getting some unconfirmed information from the net that this was the killing group, malicious group. And then we searched the information. We found out that they attacked Gigatron in February this year, and none of our institutions reacted. And we ourselves started suspecting that this was indeed killing group. As for the reaction of the competent institutions, we will get to this, but Gigatron is not an ICT company of special importance. Yes, but it has personal data. Yes, but let's stick to the presentation, please, in order to be able to cover everything. I have to say that this is not an assumption, because the file names exactly say what the files contain, and that they contain the citizens' data. What we also received was the message from the Ombudsman that nobody should open any emails from EBS or My Doctor application. And it's interesting how somebody connected this, because we also had the analysis of this My Doctor system. We can switch to the next slide. And then we used the tool that we developed on our forum, and this is the first photo that you can see. This IP address 79101, etc. And we cross-referenced different IP addresses, and we found out that the common factor for EBS, Yuzhna Bachka, etc., is one of the addresses of company NITES, which develops those systems or maintenance of those systems. And then we investigated NITES company, and we found out that some of those hits contained the data of a person who logged in the EBS system as well as to some other systems. So we found the connection between the two systems.
Još jedna pretpostavka.
Majok.
Mogla raditi, Ivan, imamo još
There's another slide. I can also say that this is an assumption, because this is email communication between one citizen that tried to contact EBS And we can see exactly through how many steps this email went. So we could see that the problem was somewhere deeper in the app's network, not on the service. What do you know? What is known about the killing group? They functioned as a group that provides the services on hire, on lease, and they use double double blackmail, and they do not attack the Commonwealth of Independent States, and they post different comments in Russian. What did you find out after this incident? After the incident, we found out that Killing Group published on its blog some documents, and in the meantime we could see that these documents contain some public information, but we found out that this also contains some very sensitive information, but we can cover this at some of the next slides. How did you investigate the incident? Yes, this is important to say that we found out most of the things using Google and OSINT tools. Let me not explain in detail, but there's nothing special. Everything is available publicly. That's why we have shared this with the public, yes. How did the attack occur? What are your assumptions? This is an assumption, of course. We don't have any logs, but what we can see on the basis of the OSINT analysis and dark web is that it was certainly a phishing attack where they received some initial information and that they used external remote services by using these credentials or exploiting them through different public resources, because we could see the exploitation of private resources, and after that they probably took over some computers and took over the administrator data, and using remote services they probably accessed domain control and databases, took whatever they needed and encrypted the data in order to complete their goal or cover their traces. And another question: which documents are in the possession of the attackers? I will say again that this is no assumption, because we saw in the meantime some data that can be obtained from the publicly uploaded documents, and there are some data marked as confidential, and if somebody has those data, this means that they can access anything in the app system, because the access to this is given by somebody with high privileges, which means that Killing Group have literally everything that they have put here, and this is no assumption. What does it mean that apps was removed from the homepage of Killing Group once? It was removed 2 or 3 times, not just once. It only means that negotiations were being held and that apps was choosing what it will pay and how it will pay. This is again an assumption. Yes, I can say that I disagree. It's not an assumption, because we know how those groups operate. There is public information with chats and the negotiators where we can see how they operate, and this is my conclusion. You asked me about my opinion. Of course, we asked the professional public to see what they could find, and it's great that this was done with without any major efforts, because without you, the public would be deprived of much information. Because on one hand, there is this significant obligation in terms of keeping secret information while the incident lasted. We still do not know what happened. And we will not get some more precise information from the institutions apart from what has already been said regarding the standards of operation during cybersecurity incidents. I think that we have 2 minutes left and we have to stick to the time. We will use the rest of our time to say that many of the things that appear to be disputable have been regulated in the law, and the public can only trust that institutions are complying with the law. We should leave it to time to see what will happen. It is still too early for the public to be alarmed regarding what happened. It's a question to what extent they will be informed about what happened in November 2023. You have the report of the General Inspectorate of the United States that control the operational security of the security community, whereas the main problem, it is said that there is the overuse of declaring the operation of state authorities as a secret. Our law that regulates in detail the obligations of the operators. Our acts on security, the technical measures, harmonization of those technical measures, and they also dedicate a lot of attention to the obligation of notifying about the incident during the incident, after the incident. There are also the responsibilities and the sanctions for those who do not comply with the law. Just a second, we will finish soon. After the operator notifies CERT or the competent ministry, National CERT notifies the ministry upon learning about the incident, during the incident, and after the completion of the incident, what it contains, what are the deadlines. Let's see after a while whether this was all observed. And you all have the possibility to address the Inspector for Information Security. You have the possibility to request access to information of public importance. You can request information about everything that happened after the incident. The second field is the issue of responsibility for action or omission to act. That is to undertake technical measures. Here we commented only on what happened during the incident, of which the public learned in the way it learned and to the extent they learned. So we have to believe, and I want to believe, that state institutions have not failed, but responsibility for the incident will have to be determined. We will have to see what data was jeopardized, and we want to see even greater transparency in future. So that's it. Can we get the microphone because of the translation?
Only if Ivan knows, or Milena, or both. Do we know whether apps used the services of the government data center or had its own servers? I don't have this data. Ivan, do you happen to know? What we can see based on online data that is available, IP addresses are mostly of the EPS and other providers, not of the data center. But just to add, we haven't investigate it all. Most that is documented on our forum is theirs. Just to briefly contribute, thank you for the presentation. Yes, I'm Lydia Komlen Nikolic. I'm a public prosecutor in the Appellate Public Prosecutor's Office in Belgrade, and prosecutor for cybercrime since 2007, when it was when this office was established. What I would like to share is a suggestion for you when you analyze the legal framework. Public prosecutor's office and public authorities that are working on cybercrime cases, they are not related only to what is in the Cyber Convention, but our criminal code provides for other criminal offenses that are computer assisted. So it doesn't mean that prosecutor's office can prosecute just for one offense. And in the interest of time, I will not mention anything else. And I don't want to avoid any conflict of interest as a prosecutor that might be in the second instance proceedings. So we haven't discussed the legal framework for more than 2 minutes. So next time we will spend 2 hours on that. And if I may get just 1 second for the final intervention, I just wanted to say that it doesn't really matter what what my group has publicly shared. It's important to investigate what this group has taken over and what it has accessed internally. So to know what is not known at this point in time. We can see that they had access to everything. They had access to confidential information how to access other sensitive systems. So I'm asking the competent authorities to do this properly, to inform the public and share all the necessary information with the public so that citizens can prepare for everything that may ensue. Thank you, Ivan. It seems that we have left very little time for this topic, particularly because it is still very topical and still investigated. So I hope that we, as partner Serbia, will have a similar event. But now we will have a break. According to our agenda, it will last until 2 o'clock, and we will talk about revenge pornography. Welcome back, and thank you for your patience. We are starting our next panel. Our next panel is entitled Violence Caused by Image-Based Sexual Abuse, and the leader of this, the moderator of this panel, will talk with Vanya Matsanovic, Internet Law Autonomous Women's Center, Diana Popovic-Gavranovic, Head of Service of the Supreme State Prosecutor's Office of Montenegro, and Alexandra Zoric. Angela, you have the floor. Thank you. And thank you for being here and allocating the time for such an important topic. Before we go into details, I would like to inform all of you that we will have a chance to hear the statement of a woman who is the survivor of this type of violence. And since we're in a week of privacy, and we want to respect her privacy, we would like to ask you not to take photographs of our interlocutor, not to record her, and to respect the privacy, what she will explain in cooperation with the interpreter for the sign language. She will tell us what she will tell us today. We will hear her, so please do not take photographs of her, and people who are following us on the YouTube channel will be able to hear her testimony. And thank you for this. I will very briefly present a study that I worked on owing to BERN, Balkan Investigative Reporting Network, about digital rights and about the problems that we colloquially call revenge porn. And in that context, I don't know whether you can see the presentation anywhere. And now you can see it. We know this term, revenge porn, and it somehow slipped into our conversations and everyday talks with this English term, revenge porn. But we are talking about sexual harassment when somebody, partner, female or male, without consent publishes and shares intimate photos or video clips in the public space, like the social media channels and so on. This phenomenon that is not typical of Serbia only, it is present in the whole world, and it creates public humiliation, fear, and anxiety on the part of the person who is the victim of that, and regardless of whether these video clips were made or photographs were made voluntarily or not, publication without consent is considered revenge porn. And what are we talking about in the context of Serbia? Serbia had several different cases of making private recordings public, mainly through Telegram. It's a messenger application for messages. And you see the dates, February 2021. There is a whole range of groups publishing and posting private photographs of women, mostly without their knowledge, and public shaming of these women. I started to work on this research in 2022. It was published in March 2023, and we found 16 active Telegram groups. These were the titles of this group. Luckily enough, they do not exist any longer. Telegram removed them, but when these groups existed, one of them had more than 50,000 members, and they actively sent photographs or video clips of women from the whole of Serbia, very often from the region, so very actively on a daily basis. And on the right-hand side, you see that all these groups were created in 2021, 2022, and existed until 2023, and you see that they had very explicit titles. And what happens in those groups? People think that Telegram is a secret application where nobody can find who they are ever, and they share video clips and photographs, ask other people to send, and they also share other people's photographs and clips. And the key thing about this is that persons whose private life is shared in this way do not know about that, and they have not given their consent, and they're probably the last ones to know about it. And what we had recently, it's not that only anonymous citizens are victims of this situation. We recently had a situation where this private video clip of a MP was published, and before that also an MP. Sorry for this mistake on the slide. It says George Mikitic, Serbian Progressive Party, but he's not. He's part of the opposition. And also there was a video clip being shared, allegedly presenting Staša Stojanović, an MP from the Serbian Progressive Party, and the idea was to humiliate her, to say that she is not a very moral person. So we have this pornography as part of political clashes in Serbia over the past 3 years. It's part of the political clashes. And what is actually the topic that we will speak in great detail about that is the legal framework, what we call revenge porn or sexual harassment through the publication of private photos and recordings on the internet. It is not a criminal offense, and people cannot be held accountable for that, but there are other criminal offenses through which certain prosecutors' offices are trying to protect victims. The primary prosecutor's office is the Cybercrime Prosecutor's Office, and Montenegro has made one step forward. They adopted amendments to the law. They have this new criminal offense called abuse of somebody else's recording, photograph, portrait, audio recording, or a file with sexually explicit content. And our neighbors, Croatia, they started to apply this criminal offense or enforce. And in the EU, this is also regulated either through the existing legislation or through amendments to regulations. This is not necessarily a new phenomenon, but the accessibility and the reach of these contents through the internet are putting that into a new context. And what we hope that will happen is this proposal that we will be able to talk in more detail with Vanya. This is a new criminal offense. Abuse of recording of the sexual content. It's been a proposal for quite a long time, and we'll talk about what can be done to make it reality. And we have victims of revenge porn, and we have institutions that need to do something, and we have platforms. Platforms whose servers are used for all this. And what did they say in our study? Telegram says it's all forbidden, you can report, and you see this report, and there is an option for pornography. And they say it's not happening, but it's happening. And they say their moderators proactively monitor public parts of the application. So Telegram is one of the applications, unfortunately, where this is happening. And I would conclude this introductory segment with this and give the floor to our interlocutor, Alexandra, who was very brave to come here and share her experience. I can tell you this is a very unique chance to hear testimony of the person who survived this type of experience and to hear about the consequences that it is producing. And because I think that this is the biggest point about this, how somebody feels in this whole story. And I would like to give the floor to Alexandra to tell us as much as she wants to tell us, and to share the circumstances of her case and her experience and her feelings while experiencing that. First, good afternoon to all. In 2020, in the summer of 2020, a friend of mine, an acquaintance of mine, Jelena Đorđević, informed me through a video call. I didn't know anything about that, and she informed me that another acquaintance sent her these photos with such content presenting some women from Serbia, and she approached Jelena Vasić because she is the secretary of deaf and hearing impaired persons in Serbia, and when she is the protector of this community, and when she told me that my photograph was there, it was completely unexpected for me. I was shocked, and I apologize. I'm a little bit excited. I will take my notes. And then this acquaintance told me what is being shared, and she invited me to go to the space where we get together, and I said I would come, and she said that there were some 10 women to whom the same thing happened, and she asked me to come together with them to talk about the legal protection that we can request, and I accepted that, and I came. And I was shocked, and I cried a lot in that period. This was a huge shock for me, and we discussed all that. I found lawyers, and then I started thinking how this could reach the internet. And it occurred to me that we have an acquaintance named Borko. Oh, sorry for this. So, a person from our community who was coming to our community to help us with the computer. And then I realized, actually he came to our house, and I realized that it was the only way for this photograph to reach it. And he was helping us to get this computer in order. I was trying to slow him down. I said, I can't see what you're doing. And then I realized that it was then that he actually obtained these photos. He denied all that, of course, but I knew it. I knew that there could be no one else who had access to that. And we started the judicial proceedings together with the lawyer who is sitting here next to me. He denied for a long time. He didn't want to admit to doing that. But last year he finally did it. He was trying to shift the liability and the responsibility. He was trying to avoid confession. And then he hired a lawyer. I don't know whether that he did that based on the lawyer's advice, but he confessed to that. And I don't understand why this is lasting for such a long time. We filed a report in 2020. Now we are in 2024. He finally confessed. He pleaded guilty last year. He said that he had shared this intimate recording of mine talking about my my psychological status. I couldn't sleep, I couldn't eat, I lost any will to live, I couldn't do anything, and a lot of support that I received from my family members and friends meant the world to me, and so support of my family. And I was gradually going back to normalcy, and I know that don't want to give up. I want him to be sanctioned, so that it's a message for others and some kind of satisfaction for me for all that I've been through. Thank you, Alexandra. It's very important to hear directly from about how somebody can feel about that. If we can hear some more details from you. You said that the proceedings lasted for a long time and that the outcome was successful. So where do you stand now, and what do you do in relation to your case now? Now we would initiate civil proceedings to get compensation for damages. It's all right. I mean, it's good that he confessed, but I believe that he should pay some damages to me, and that could be also a lesson for him, never to do anything like that again. And Alexandra, you had legal support of the organization that helped you go through this process. Of course, that made things much easier for me. Okay, maybe we can hear other interlocutors now, and we can go back to Alexandra's case if there would be a need. But can we start with Montenegro? It's good news that Montenegro has amended the law, and now you will have a chance to prosecute such cases. Not you personally, but the judiciary in Montenegro. That also required time, probably to reach some social consensus that it is important that women in Montenegro should be protected. Women are mostly the victims of this, unfortunately. And I read about a case in Montenegro this summer where a girl was blackmailed, and over 1 year she gave almost 10,000 euro to a person who constantly threatened with sharing their private recordings, presenting also him. And since she had no more money, she went to the authorities and reported him. So what's happening in Montenegro? What do you expect in the future?
Before I answer your question, I have to express great respect to the lady who came here to talk about this difficult experience of violence that she went through, and my respect for her suffering and for the dignity that she preserved. And this speaks a lot about your strength and the support that you had. Unfortunately, all persons to whom this happens go through hell, like you talked about what happened to you confusingly, but if you talked longer, there would have been much more about your suffering. What happened in Montenegro? The initiative for the introduction of this criminal offense was made by the NGO Prima. They created a study called revenge porn in the criminal legislation in the countries of the region and in Europe, in the countries that have this crime in their legislation. And they determined that 11 EU member states had this crime in their legislation, criminalizing distribution, dissemination, sharing, and publication or posting of such content about a person without her consent, without using the term revenge porn. And I think that it's easier to use this term because it only consists of two words. In our case, this is called abuse of somebody else's recording, photograph, or document with sexual explicit content. So you need two lines to write this, and that's why people use the abbreviated form. But when we say revenge porn, this diminishes the importance of this crime. Some might say, well, a partner might be in a revengeful mood towards his partner, and people forget that it's inter-partner, very frequently gender-based violence in intimate relationships and sexual violence as well. This is frequently forgotten. And in addition to going through violence in that relationship, the victim is linked to that pornography, and which is an additional burden for the victim. That's why we should not use that term, although I think it's used in the United States just like that. What the study of the Prima NGO showed, and I will stress this, I work with children who reach the criminal proceedings because they are victims. It's a positive experience of Belgium, where 5 years of prison is envisaged for an adult victim of this crime, and if this is a child, the prison sentence is between 10 and 15 years. And I think that these sentences show clearly how difficult this crime is for the person who experiences that, and how dangerous it is for the society. And what I like the most about the Belgian aspect is that they have actually that the lack of consent of an underage person is something that is not proven. That goes without saying. It goes without saying that they have not provided their consent for the sharing of sexual content. And this was accepted, this initiative and this study was accepted by the Ministry of Justice of Montenegro, and they also took into account the objections of the professional general public to the application of the criminal law protecting citizens from this type of crime. They also took into account the recommendations of the European Commission, the recommendations of the competent authorities, of the competent bodies of the Council of Europe and the United Nations. And the introduction of this crime also relies on Istanbul Convention, Article 8 of the Convention on Human Rights of the Council of Europe. And I would dare to say, although I'm not a lawyer, that it also relies on Lanzarote Convention that pertains to the protection of children from all forms of sexual abuse. And as we, the form in which we introduced in our criminal law this crime is in the chapter that pertains to crimes against sexual freedom and rights of man and citizen in our criminal legislation. So this chapter would be translated into also the violations of rights of privacy, especially where children and adults are concerned. I would prefer to have seen this new crime in the chapter that pertained to the violation of sexual freedoms, and this is what Croatia did, and they introduced this crime into their criminal code. And what happens now if somebody is prosecuted and sentenced for this crime? What are the punishments, and what will it look like? As you said in the introduction, for the basic form of this crime, the statutory sentence is up to 2 years. And this is introduced if somebody makes available some content about the person that contains explicit sexual contents without the consent of that person, or if through misuse they make new content of that kind, or change that particular content and makes it available to somebody else. In that case, they can be punished by up to 2 years of prison. But if they do this through information systems, in other words, if they make it available to a larger number of people, then it's a prison sentence of up to 3 years. Also, if this crime is committed against a child, the crime is punishable by between 1 and 8 years of prison. And if this is done by an official person while performing official duty, the sentence is between 3 months and 5 years. And if it is committed against a child, then it's between 2 years and 10 years of prison. And what is important is that Montenegro prosecutes those cases ex officio, which clearly shows shows the importance that it awards to this crime. Yes, maybe this is a good opportunity for us to talk about what is going on in Serbia and the initiative that Autonomous Women's Center had made some 2 years ago, maybe longer. Where are we now? Potentially wanting to be where Montenegro is today. Thank you very much for the invitation and for the possibility to talk about this topic. And I would like to thank Alexandra for sharing her experience. I'm sure that we all have 1,001 questions about what she did and how she proved the perpetrator and how she came to the conviction, which is not easy. Unfortunately, these are exceptions. I would like to go some 10 years back to the time when the state adopted a strategy for cybercrime. This was done by the Interior Ministry, and they focused on cybercrime in the sphere of embezzlement, financial aspect of cybercrime, and sexual violence against children. So women did not exist in the strategy at all. I think that even the EPS case could not have been perceived in that strategy at the time, and I'm not aware of any new ones today. But I want you to know that our state does not have any perception of the importance and the existence of those crimes, and that the state should react to them. So 10 years later, we have an expansion of crimes committed through the internet. This crime is just one of those that are committed through the internet. And our criminal legislation remained in the early 2000s, trapped without having a good institutional response to what is going on now, to how internet is being used and those how information technology is being used for the commission of crimes. Our colleagues in Croatia succeeded in securing a place in the criminal law for this crime because women's organizations cooperate well and have always cooperated well, and we were really glad, and we wanted to introduce this too in our legislation. So we were in contact with our colleagues from Montenegro, and we shared this with them. And now you see the difference. Colleagues in Montenegro and we started talking about giving an initiative to the state to introduce this crime in parallel with each other. Let's give them something for the beginning to discuss in order to get it. And in December last year, Montenegro adopted and introduced this crime in the criminal law. Maybe it is not exactly phrased as it was discussed by the women's organization, but we are what we are, where we are. And the only thing that happened between May 2022 and December last year was that there was a meeting between the Working Group for Amending the Criminal Law and our organizations, and it was said at that meeting that the Working Group was not even reviewing this crime. And in that discussion, they constantly tell us that there's this crime unauthorized publication of recordings, etc., etc. But this is prosecuted by a private lawsuit, and there's no way for you to prove that somebody from some IP address shared your photographs, your private photographs and recordings, without the support of the state apparatus. Cybercrime police and cybercrime prosecutor's office that can request a court order to see what kind of IP address was involved and everything else in order to get to the perpetrator. You cannot do anything. You, as a private prosecutor, cannot take somebody's laptop and the telephone to see whether they have sent something. That's impossible. As a private prosecutor, you don't have a chance in hell to prove this. And as regards the punishments for that crime, they are ridiculously low. We also talked about the statute of limitations. As soon as you start, the statute of limitations has already set in. When the photographs and the recordings were in the newspapers, in magazines, on somewhere else, it is the time when this provision was introduced in the law. So the Ministry of Justice does not see this as something that is bad in our society. They think it's enough to leave the victims alone, to file private lawsuits, that all of them will have enough money for the private attorney, that they will have the mental capacity to deal with that, and that is their message, right? Well, a stumbling block in the discussion was that the working group did not understand, actually understood that we wanted this crime to be prosecuted as officio, like in Montenegro and in Croatia. Our proposal was not like that. We proposed this crime to be prosecuted at the motion of the victim, but to prosecute as officio in the more serious forms of the crime against underage persons, against a larger number of persons. So this could all be something that would pertain to those Telegram groups. In other words, not to leave the author of this Telegram group unpunished. Maybe this is a good place to remind ourselves. It was Women's Day 2022, and there was a news report that Nišlike Telegram group appeared on Telegram with recordings and photos, explicit photos and recordings of women and girls from throughout Serbia, and the Interior Ministry reacted expressly. They arrested the organizer in a few days, and we never found out what happened with that case. We tried as much as we could by the end of this year, when we learned that the Cybercrime Prosecutor's Office dismissed the charges, which means that nobody in this country will suffer any consequences because of the fact that some women, mostly women, went through enormous stress and trauma. And the reason why the administrator will not be held liable, although it is known that he gave statements to the media and that he set up the group, was because he personally had not sent a single photo. But he made them available to 30,000 people. He, like, naively set up this group, and he did not know what was going on. I can personally witness for all Telegram groups that I followed, that nobody is there because they're interested in the news. Those groups have been created for just one purpose, not to talk about whether it's nice weather outside or not. So this case is over. I requested, and probably you, this decision on dismissing charges, and the prosecution denied us this. I'm trying to get to this decision through the commissioner And we do not know, because of that, what the prosecution did, whether they talked to the victims in those proceedings. When this news came out, we resorted to the social media and asked the victims to contact us in order for us to be able to object to that decision. We wanted to see what was done, but none of the victims contacted us, which which actually makes us wonder whether they were contacted at all by the prosecution. These were girls whose telephone numbers were shared. They were intercepted by completely unknown persons in the street, men in the streets, who knew who they were. And if the cybercrime prosecutor's office did not have enough elements for prosecuting them for that particular crime, there were other crimes for which they could have been prosecuted, but they needed to talk to the victims. And to us, it seems that as if they had not. I don't know, of course, and we do not have the means to review this decision because we do not have a single victim who contacted us saying that they have complained this. And the message is, it doesn't really matter, new groups will be set up and nobody will prosecute this because nobody is interested. This is a huge amount of work. Let us not be mistaken, it requires a lot of work on those cases. Those of you who were at the previous session regarding apps was able to see what needs to be investigated. The same thing is with the unidentified perpetrators of this crime. The victim has to hire an IP expert in order for them to determine the sequence of steps and to trace the crime back to the perpetrator, in order to be able to go to the prosecution and file a report on the basis of this. In this report, which I conducted with Birn, I had the opportunity to talk to the cybercrime prosecutor's office, and there were different things there. There are prosecutors who really want to solve those cases, and there were cases in which there were some other circumstances, such as blackmail, or other types of sexual harassments constituted an element of what we are talking about now, the publication of recordings, and this could have been packed up in that single case. But talking to them, this was regarded either as a personal initiative of the prosecutor, whether the prosecutor will really make an effort to do something about it, and whether this girl was fortunate or unfortunate enough to have this other circumstance in her case. And it all came down to the situation where if there are other elements, we will prosecute them, and if not, nothing. And this is also important in terms of security of victims, because those Telegram groups share Instagram accounts, private telephone numbers. And it all works like somebody says, does anybody know her? And somebody else will say, yes, I know her, she's from Voždovac. And then another person will say, well, yeah, she was my mate's girlfriend, and here is her telephone number. And then on the next day, she receives thousands of messages from unknown persons. Some of them request her to meet with them, some others don't. And you have no idea how somebody found out your telephone number. And there's another trend, mostly among teenagers. It's on Instagram, and these are the so-called spotted pages. For example, an account where somebody will take a photo of me in the street and will say, who is this person? I saw her there, and this will be published on this Instagram page, and somebody will recognize me and send my phone number. And this goes on among teenagers, and they think this is cool, they chat, they communicate between each other. But in those situations, we never know whether some predator or a violent person or some other person will get the telephone number of this teenage girl who walked along the street innocently when somebody published a photo of her. This is important in terms of privacy, in terms of the way in which somebody else's information is found out. There were cases in Montenegro, unfortunately, like the one that I mentioned that occurred last year. How did you prosecute this before the adoption of this provision? Did the prosecutor's office try to deal with it in the same way as here? Yes, because in our criminal law, there are 6 other similar crimes which could have been used for prosecution and court proceedings. Unfortunately, where children are concerned, the abuse of photos of a child occurred together with a more serious crime, such as the rape of the child. So when children are affected, everything is much more complex. But then this abuse of the recording is also included in the charges in addition to this serious crime. We do not understand how horrible this is when it is posted online, when thousands of people see this within seconds. You can delete it from the account, but you never know who kept it in his private files and who will continue sharing it. There's no end to it. And I suppose that that's why victims do not respond, because they only want to be left alone. Based on my experience, some children who were victims of rape say that going to school and everybody mocking them about this is worse than that horrendous crime. We simply do not understand how big the damage is when something is published and posted on the internet. It's not just psychological violence, it's a serious violation of mental health, impairment of mental health, and of the person to whom this happened. And when we talk about adults, their business life is also threatened, because who would like to employ a person who is the target of such, who is the subject actually of such stories, and when those stories appear, that person is actually marked as somebody who is the potential target of future abuse. And this is how the state should treat somebody who went through this crime. Vanya, you're probably contacted by victims. What is your advice when you're contacted by somebody? During this research, I had the opportunity to talk with about 30 women from all over Serbia who experienced this kind of violence, and the universal thing for all of them was that they did not know what to do initially. Whether to shut off, to shut down everything, to burn down the computer, to remove my accounts from social media, to report them or not, go to the police or not. And if I go to the police, should I show them the photos and recordings? Who will see them? Will they ask me to remove my clothes to check whether this is really me? These are some questions which are really incredible. What will the proceedings look like if the proceedings happen? Who will provide me with psychological mental support? Should I tell my family about this? Should I tell my employer about this? But what if my employer finds out about this? I talked to some girls to whom this happened while they were in high school or at university, and the institutions had no idea on how to react. Schools only want to hush this up. They don't want anybody to hear that something bad is going on in the school. Teachers, there are numerous elements of the society who could be the part of the solution. But what does this look like right now, according to your experience? talking to victims. It's a prejudice that this happens only to young women. In fact, this happens to women of all generations. It happens also to men. So any of us can become the victim of this crime. This is indisputable. It's just a question, what do you do at the beginning and how do you react? And it's a matter of training. Research has shown that the expansion of this crime started with the COVID pandemic when we all communicated online. And at the time, most of the applications for online communication did not have the option informing you that the conversations were being recorded. And at the time, many women were recorded without being aware of that. Or even with their consent, they naively shared their photographs or recordings with persons, but with particular persons or a particular person. We had a case of a girl in Serbia where a girl shared her photo she gave her photo to a boy, and then her father found out about this, and he created the bigger damage because he shared this, this is this lack of understanding. What do we have the right to share, and what kind of photographs can we share with other people without consent, even when those photographs are not sexually explicit? We don't have this basic culture, that's for sure. And when you give free legal aid to women, and we are contacted by at least, actually on the average, by one woman per week, you are in a situation to tell them that this will be very difficult and that they cannot expect to be protected by the state. Let's see what you can do in order to protect yourself. And the most important thing is the way in which she will collect evidence. It is not just making screenshots of the messages. If she receives something, she has to copy the HTTP link in order to be able to trace it. If they threaten to publish this shame that women have to swallow up and to tell the people who are near to them that this might happen, in order to enable them to screenshot everything as soon as this appears. We all know that it's easy to delete messages and then you lose evidence immediately. And you have to make a screenshot of that immediately in order to have evidence against that person. And in some difficult cases, we had some cases where some recordings were posted online, and the woman engaged IT experts to try to determine how, and finally it turned out that this was posted in one place, but since the perpetrator was an IT expert, he did it through a Russian server. And then we have to wonder whether this is something where our prosecution has jurisdiction. And how do you establish the jurisdiction of our authorities if somebody uses foreign servers? And this is a really serious problem. She filed a private criminal lawsuit and did not succeed. Unfortunately, she had to pay the cost of the proceedings. With all due respect for all those who are in the IT sector, those who are violent and know all those IT techniques are much greater violent villains than anybody else. Sometimes we don't know what is going on, but we live in this world where you cannot be cautious enough, and we have to learn to live and to protect ourselves, particularly in this space, in online space, rather than in the street.
Do you know, maybe we have a criminal offense in Montenegro, but it should now produce some positive effects and be applied in reality and try and protect victims. So were there any discussions about training courses for law enforcement For example, one of the girls that I talked to, she had very positive experience with police officers. He said it's a private lawsuit, I can't do anything about that. But he didn't judge her. He even went to talk to that person. He used his authority as a police officer to send the message that the police know about that. And another person had a very negative experience. Like, oh, that's your private life. A guy has his needs, so some misogynist comments. And so that police officer is very important for further destiny of the case. Do you have any information about how it works in your country? Yes. While we were discussing here, that was my initial thought related to early education for everyone, from children to experts. We can be highly educated, following international standards, but some prejudice can prevent us from applying what we know and what has been adopted. And this first response is very important for the victim. So when we talk about children, even parents, when hear something about that, they are shocked and say many improper words, and that acts as an obstacle to children reporting that. And this is very important for law enforcement to have these training courses so that criminal offense can be applied and tried, and very important for the protection of a victim, to prevent any further sufferings by the victim, and for the treatment of the victim in a protective environment and protective procedure. And the next question is related to the level at which our cultural victim protection is. We have criminal proceedings, and this part related to the protection of victim in criminal proceedings will be added, and that this will be additional help to victims. I would like to give the opportunity to Alexandra to say a couple of words more after hearing all of us, if she finds it okay. Maybe about her message based on her experience with this process. What works in this process, what doesn't work, and particularly in the context of the amendment of the law aimed at prosecuting this offense in a much more serious way. So maybe we can hear Alexandra's opinion about that. In any event, this practice should be improved. My personal strength and the decision not to give up is one thing, but the other thing is to make it somehow efficient, to have the right penalty and real penalty, that they cannot get away so easily with what they've done, and with the influence that they had on victims' lives. I was humiliated in the eyes of everybody in the entire region, and it's not a small thing. And these sanctions have to be specific and relatively quickly. And the victim has to get some kind of satisfaction. The perpetrator should not get away with this, and the victim should not be left without any satisfaction. I had support, and that helped me to get somewhere, but this proper sanctioning is satisfaction that can encourage victims. I will not give up, as for me personally. And what would help me and what would help in not giving up is some more concrete system for redress. For example, these abusers, he was going into the community and saying she stands no chance. Even if she sued me, I would never be sanctioned. And that was additional burden on me. And people who are doing that, they have different personalities, different characters, and a way has to be found to prevent them from doing that again. And just to mention once again, I don't want to give up. This has to be sanctioned. This is really brave, and I hope for the best possible outcome in the context of this system. But what was the outcome in this first segment after he pleaded guilty? So what can be expected in the second part in relation to the private lawsuit? I was served a summons from the lawyer. And actually, I got a decision, a judgment in this first proceeding, and when I read all that, I realized that there is no mention of any compensation for damage, and I talked to the lawyer, and I was instructed that we can institute civil proceedings. As a lawyer, you just need to take the microphone. He pleaded. There was a plea bargain and a plea agreement, and he had to pay just the costs of attorney. But now we should proceed with the civil case, civil proceeding. But I want to say that criminal courts never award damages, although they have this option to do that in criminal proceedings, to shift that to civil courts and instruct the victim to institute civil proceedings. And this is another ordeal for the victim. The proceedings are shorter. You have the decision of the criminal court that somebody is guilty, but she has to hire a lawyer, go through this again. So I think this is a big shortcoming in criminal proceedings, that judges are not awarding any damages, and they have all the mechanisms in their hands to do that. There is no need to push that to civil proceedings. We put forward many pieces of evidence in the beginning, and as Vanya mentioned, it's not enough to screenshot things. You have to send URLs and similar stuff, and the police did a great job there. But the cybercrime prosecution office is overburdened. They're seriously understaffed, and the COVID pandemic and isolation and the war prevented many things from happening. So, as colleagues Vanya and colleague from Montenegro said, it is necessary to work on your case very thoroughly, to supply a lot of evidence. You cannot rely just on preparing a criminal complaint. You have to submit all the evidence that you can obtain, and you have to bear in mind that these offenses are very complex, although the prison sentences that are visited are low, but and I believe that the judiciary do not have enough specialists in this field or expert witnesses from the IT industry that could be called as witnesses. So the more evidence you present, the better for the victim, but it's a long battle. And it's important for lawyers to communicate with the victims and to tell them how difficult this will be, how long this will be, that nobody can guarantee a positive outcome. But as Alexandra said, no, people should not give up on that, on their attempts to get justice. This is the positive message. And do we have questions? We will have some 15 more minutes for questions and comments. And I can stand if it's like it's okay. Yes, but we can finalize this panel after hearing the audience. I'm simply thinking about the profile of these persons. That person who did that to me, he did that to his cousin, to his sister. These are horrible things. It would be better to have more serious sentence that would really stop him from doing that. These are really horrible. A sister, cousin, another 12 persons, this should be punished more seriously. Yes, this case is really horrible. That sounds horrible. I'm really sorry that so many of you were exposed to that, particularly in your community. I believe that it was additional pressure. And we can start with questions. I would like to somehow add a segment, social and criminal legal aspect, and a different angle. I don't want to say that it's an opposing angle. First, I have to say that I'm in an awkward position. I'm the only public prosecutor here, and we keep mentioning public prosecution. I'm a public prosecutor in the appellate prosecutor's office. I presented myself in the first panel, and back in 2007 I was the first prosecutor for cybercrime. Branko Stamenkovic is now performing this duty. And I have to recall back in 2007 we had some cases of revenge porn involving some public figures, some celebrities, some singers, Suzana Mančić and Severina. And this discussion about revenge porn has been going on for a long time in professional circles. And the stress was always on the need to have a broader social dialogue, precisely because of these specific features and complexities, primarily related to the psychological status of the victim from the standpoint of criminal legislation. Criminal legislation is a repressive system. You react post festum. Vanya mentioned this working meeting involving the organization OCDs, and I come from the prosecutor's office. I would be very careful with introducing the ex officio prosecution. More in favor of the Croatian arrangement, so prosecution based on the initiative of the victim. But the idea is to act preventively. we need to discuss what we can do with respect to prevention and discussing such events. I will give an example of endangering security. Way back in 2007, when for example, if I said a journalist or anyone, I would kill you, that was prosecuted based on a private lawsuit. And a whole series of events and threats on social networks to LGBT population members and so on and so forth. This led to amendment of the law. And this can be applied to revenge porn. So we have a criminal offense that is prosecuted based on private lawsuit. And you, Vanya, colleague Branko Stamenkovic, made a statement for television, for the local television, but it cannot be found, these statements. We had a professor from Belgrade University Law School, and positions on criminal offense, whether to introduce that criminal offense or not, were different, what modality should be applied based on the proposal of the victim or ex officio, so on. So we need to discuss, not only because of the objective reasons whether our prosecutor's office and police can actually do that, bearing in mind their resources, but also because of other reasons. Any influence on in criminal legislation and amendments to the criminal code. For example, for this lady, any amendment of the criminal code will not mean anything to her, because it will not be possible to apply that retroactively. But I have to congratulate her for her courage. Many victims do not have that kind of courage, and of course, it's important to have a good attorney at law. And another important thing, public authorities cannot restore your dignity in criminal proceedings. It's not the way to restore your dignity, this feeling of privacy, your intimate sphere. So this is devastating in my view. So we should think very carefully about that and not proceed too lightly with amendments. And most of the professional circles were against the most recent round of amendments to the law in 2019. We are amending it maybe too often. Thank you for these suggestions. I can agree with you that this topic deserves much more attention in the public, and opening different aspects for discussion about this. And just to mention about the case that was dismissed by our prosecutor's office, for this group, Nišlike, our office is working on cases involving children, minors, and if persons who are adults, persons who are involved in this case are adults but have not been identified, they will not get decisions on dismissal. So proceeding so that they will continue, the prosecutor's office will continue working on this. Can I ask a question? But I think several people also asked for the floor. We can start. I have a comment and several questions. First, the fact that kids would play detectives to find the numbers of the girls that liked, because it's nothing strange. The whole Facebook concept was created because Mark Zuckerberg was rejected by the girl he liked, and then he offered an opportunity to his colleague to evaluate women and then everybody else. So this is the concept of Facebook that is used in different ways, even today. And the questions that you mentioned, Angela, they're all relevant, but we have to bear in mind the situation where the employer has insight in your correspondence and what you're doing on your social media. And third, because of this huge number of IT experts all over the world who know how to hack and they know how to hide their traces, it is necessary, as in the case of wars in the Balkans, it is necessary to have an international legal body that can deal with transboundary cases, and there are no boundaries on the internet. I'm Anna Marakosic, and I'm a victim. I will not use this term, revenge porn, because I was never involved in pornography. Thanks a lot. I'm sorry to hear that you had that experience, and thank you for sharing this with us. And just one thing to add with relation to what you proposed, that it should be a transboundary thing. The European Commission discussed this problem in the territory of the European Union during last summer, and they are working now on a potential creation of a body that will try to harmonize this type of legislation and help to increase the speed of investigations. As you said, it's not just these groups that were mentioned here, they do not include only people from Serbia, but also people from other countries. And then we have the legal issue of territorial jurisdiction. So it's very important to say the internet has no boundaries. None of these applications have any boundaries or frontiers. So I agree with your observation. Thank you.
We had some other hands. Thank you. I have a comment and a question. But first of all, I think that this topic can really hit us hard. I'm fortunate enough to have grown up before Facebook, and what we've heard can really, the target can be anybody. My name is Nevena Ružić. I deal with the protection of data. I've been dealing with it for a long time. What do we do? One of the things is to be cautious, but what we do not want as a society is to have individuals who start from the premise that they will be defrauded and who will start dealing with people feeling that they will be fooled in some way. And this is something that we want to share with people. Instead of saying, be cautious, we should reinforce the individuals and try to make them strong. I really admire all the speakers, and this should really be shared, and parts of ourselves probably say this in this way or another. But it's important to explain to individuals that they should not regard everybody else as their enemy. This is not the solution. We should find positive examples and we should reinforce them. What if the worst-case scenario happens? Well, then we should teach the others that the fact that somebody made a mistake is normal. This is my comment. And the question. We talked about the photographs which are disturbing for individuals and which reveal some of their naked parts, and I agree, people do not engage in porn, and it should not be called revenge porn. But there were cases where photographs were used and they were photoshopped in such a way that it looked as if some girls were actually nude rather than the person in the picture. But how was that covered? Was it covered by the same crime? Because the photograph of the body, the naked body, actually the body did not belong to the head, to the person to whom the head belonged. Unfortunately, they already belong, owing to the AI applications, which gave the opportunity to everybody to edit perfectly, and they don't have to spend 10 years learning in order to create such a photo. Would you like to comment? Maybe I was not clear enough in the introduction. So the sentence from paragraph 1 of our law shall be imposed on whoever uses the computer system or any other way to develop a new or change the existing photograph, audio recording, video recording, or document, and makes it available to a third party as truthful, offers it as truthful. And they will be punished by 2 years if they're an adult, and if it's children, it's up to 8 years. You, in your example, addressed deepfake. Yes, Croatia introduced this, that also those edited photographs are included. They belong to that crime, and this was accepted in their case, so this belongs to that. But let's make a parallel. We had this, who is making bomb scares at schools. And it turned out that this was done by minors, by hiring through video gaming people from the Czech Republic to make those bomb scares. So you can see how widespread this is. And the state said, in the end, this is to be investigated. They invested a lot of effort in finding those minors, and we will see what will happen to those minors, because they filed criminal reports also against their parents. And the question is how the system will react to all this. The fact that everything was swept under the carpet actually resulted in this explosion. And this is a huge workload, investigating this, finding out what games were used by them to identify the people in the Czech Republic and to pay them. It took a lot of effort, so you can imagine if this had to be done in each and every one of those cases. We do not have enough experts who can do this. Our judiciary is also flooded by numerous other crimes, and they don't have time for such cases. And I think that our cybercrime prosecutor's office needs to be set up differently. We need to return this under the jurisdiction of the basic prosecutor's office. We cannot have a single cybercrime prosecutor's office for all of Serbia. It's simply impossible for them to cover everything. We have exceeded the number of crimes that our prosecutor's office can cover. Why cybercrime prosecutor's office is specialized? Because of jurisdiction, because we do not want to talk about the place of commission. The perpetrator can come from whatever part of Serbia. This is handled by a single place, by a single unit. It's indisputable that the capacity has to increase. This is indisputable, but we should be cautious regarding what is to be prosecuted ex officio and how. I'm not against it. I'm in favor of the Croatian solution, but we should be cautious. Any interference of criminal legislation in certain cases could produce the counter effect. I will give you the example of the crime of rape and the amount of unreported crimes. And this is the crime that is prosecuted ex officio. The issue of the victim and the psychological and emotional attitude of the victim towards what happened is the most important thing. This is This is a completely different story. We were talking about this crime, and we could talk about the lack of humaneness of the system whenever somebody comes to report a crime against the sexual freedom or whatever the other right that was violated might be. The institutions have not shown sufficient empathy. It's really a complex issue. It's good to be aware that this is a problem, and not only for this, but also for any other topic that I worked on. I did not like the fact that people were disappointed with the system, and this leads us to the failure to report to the dark figures. Any other questions? Thank you for calling us. I come from the Office of the Commissioner for the Protection of Equality. I'm really pleased to be here at this meeting because this topic has been very interesting for our authority for years. We made this initiative together with the Autonomous Women's Center to introduce this crime. We thought that the law should go hand in hand with real life. And what has been going on lately in the digital area, and when we look at the consequences of those crimes, we realize that this will have to be regulated legally. First of all, in order to inform the perpetrators that this is something that is prohibited, and secondly, to tell the victims that some kind of justice exists and that some kind of punishment for that crime exists. What was worrying for us is that the consequences of that crime are horrible, because if you look at Serbia after COVID, more than 70% of people have started using internet on a daily basis, which means that consequences for you are unforeseeable. They can be created literally within minutes, and this exceeds not only you, but your family, your next of kin. And when we talk to the victims, this makes them so traumatized that they find it very hard to get out of this constant circle of violence, because even 10 years later, a recording may come out, might get to light again and re-traumatize you. And it is difficult to amend the criminal code, and the system has to give an appropriate response. This does not mean only to include the criminal offense in the law, but leave the institutions as they are. We need to change the institutions in terms of capacity, good human resources, and all other capacity. We at institutions need the capacity. The story of this woman moved me so much. First of all, I work in an institution which deals with such topics, but this touched me deeply as a human being. And I realized how I myself to this day did not understand what this crime was and what it brought. And I think that we need to start talking, but not only talking, we need to start working in order to be able to keep up with life, because the law has to keep up with life, no matter how complicated this might be. All of us in this room might come into that situation that our head is edited on somebody else's body, or our kids, or our mothers, or somebody else's. I apologize. I had to thank this lovely woman who talked to you as organizers, because this is an extremely important topic and something that is so present and increasingly present. Thank you very much for raising your hand, and I'm sure that Alexandra's story is very emotional for all of us, and we're very glad that we could hear it. And thank you, Alexandra, once again that you wanted to share this with us. I think that we'll have to finish now unless somebody has a very, very important question. Well, and I would like to thank our guests. First of all, good luck in Montenegro. I hope that this will be applied well rather than remain a dead letter, and that your initiative, joint initiative, yes, will be successful. I think it's good for all of us, regardless of how it will be regulated. And this is a big invitation for all of us to join the discussions, because there are many, many elements that deserve to be included, as well as institutions, in order to encourage people to go to and report the crime to the police. Thank you for the conversation. We will finish with this, and we will now give the floor to Nadia. I think that this applause tells us all. Thank you, Angela. I would like to thank all the panelists. Thank you for the story that you shared with us. And I think that this just scratched the surface of all the things that need to be discussed. This panel marks the end of the second day of our Privacy Week. We invite you to follow us and watch us tomorrow as of 11. Preserve your privacy, protect it, and request from institutions to protect you whenever you need protection. This is their duty. Goodbye.